Well, welcome everyone. My name is Ian Ballin. I am Executive Director of Stanford Center for the Digital Economy and an Internet litigator at Greenberg Traurig in Palo Alto in LA. On behalf of the Stanford Center, I'd like to welcome you to our presentation today, New EU Rules for Digital Services and Markets, How US Companies Can Get a Head Start on Compliance. We've got two highly qualified experts to talk to us from Brussels and Dublin today. Francine Cunningham from Bird & Bird and Claire Kelly from Google, and Clary Gottlieb. Both of them will introduce themselves in a moment and then talk about the DSA and the DMA. Let me just at the outset mention that if you are interested in getting involved in the Stanford Center, please reach out to me or to Roland Vogel. We will be having our annual Best Practices Conference this fall, November 12th. And we are always looking to get new people involved in the center. So with that, let me turn it over for self-introductions, starting first with Claire.
Thanks, Ian. Hi all, my name is Claire Kelly. I'm an associate at Clary Gottlieb, Steen and Hamilton, and I work between our Brussels and London offices, focusing on competition antitrust law. For the last 18 months, however, I've been working at the competition team in Google. I've been doing a range of things, from working on various investigations to internal counselling. One of my main areas of focus has been on the DMA related work. So that encompasses both helping the business to understand what the DMA says and means for Google, and also helping them start to build for compliance. So I look forward to discussing the DMA with you later today.
Thanks, Claire. We're delighted to have you. And Francine?
Hello, everyone. My name is Francine Cunningham, and I head the Regulatory and Public Affairs practice of Bird & Bird in Brussels. I won't be joined by many of my colleagues this evening because Belgium is playing in the Euro Soccer Championship at this moment. So I've got the short straw this evening. I've been working with the EU institutions in the field of digital regulation, media, and intellectual property for the last 2 decades. I actually joined Bird & Bird only in 2018. And prior to that, I was working as a senior specialist at the US mission to the European Union in Brussels. So I was a local hire for the US Commerce Department. So I'm always happy to be back with American colleagues. So back to you.
Thanks, Francine. And let me say for those in the audience, we do want to make this as interactive as possible, recognizing the limitations of the medium. So if you have questions, please put them in chat, and we do want to allow questions. Feel free to ask your questions during the presentation. You can also upvote questions. Let's start by getting the view from Brussels on the DSA. Francine?
Sure. Let me just see if I can get the slides back on screen. Or Giselle, I may need your help if it doesn't work.
I think we see them, or at least I see them.
Okay. Yeah.
They're currently still on the screen.
Okay. Let's see. And strangely enough, it's not letting me access them. Just a moment.
I can share them for you.
It's okay. I've got it.
Okay.
Okay. Yeah, got it. Okay, sorry about that. Well, first of all, I want to introduce the Digital Services Act. So the Digital Services Act is based on the idea that online platforms are so central to our everyday lives, as we've all experienced during the pandemic in particular, that they require specific regulation that's over and above the normal sector regulation and the regulation that applies to labor law, consumer rights, taxation, etc. So the EU institutions became convinced that along with all the benefits that platforms bring to European society and the economy, they also pose risks to users' rights, to information flows, and to public discourse. So on this slide, you'll see some of the public policy goals the Commission is hoping to achieve with the Digital Services Act, including less exposure to illegal content for citizens, and reducing systemic risks such as the misuse of digital services for the purpose of misinformation or in order to manipulate public opinion. So the DSA is above all a very ambitious proposal. The EU institutions have, I think, been emboldened by what they see as the success of the General Data Protection Regulation. Now, a lot of the lawyers listening to this probably don't necessarily regard it as a success, even if it's created lots of work for all of us. But the EU institutions regard the GDPR as a huge success in setting global standards, and now they want to be the first mover when it comes to bringing in horizontal regulation for the digital market. So in short, it's an attempt to apply European values to the digital ecosystem. So who will be regulated? Well, in brief, information society services and intermediaries, online platforms such as social networks and online marketplaces, they are considered to be a subcategory of hosting services. And of course, many providers of intermediary services may fall under different categories, and the measures are cumulative. And very important to note that the DSA provisions will have extraterritorial effect. So they will apply to US companies established outside the EU, as long as they provide services in the Union, as shown by having a substantial connection. And this is to ensure that EU citizens are protected no matter which service they choose to use, and to avoid union-based digital services being subject to a competitive disadvantage if they have to deal with more regulation than their US or Chinese counterparts. So again, that extraterritorial reach is another sign of that ambition I mentioned earlier. So the DSA will take the form of a regulation rather than a directive. That means it will be directly binding on the 27 member states. And this is to avoid legal fragmentation, since member states may otherwise introduce their own legislation. Regarding liability, the Act will retain the core principles of the e-commerce directive, which, as you all know, has been in place in Europe for the last 2 decades. So Articles 12 to 15 of the e-commerce directive will actually be cut and pasted and reproduced in the new regulation to make it clear that the legislation will retain the safe harbor protection from liability for information society services and the prohibition of general monitoring. An added piece of assurance for online platforms, which has been inspired by US law, is a new Good Samaritan style clause, which means that service providers who voluntarily take down illegal content will not have any negative consequences by losing their safe harbor. So what are the specific provisions you need to prepare for? Well, first of all, intermediary services will have to set up a single point of contact in member states where you provide services. And if you have no establishment in the EU, but you offer services there, excuse me, you will have to plan to designate a legal representative in the member state where you do provide services. Note that this legal representative can be held liable for non-compliance along with the service provider. So you need to plan carefully to designate both a point of contact and a legal representative. Then turning to content moderation, which is really at the core of the DSA. as we've seen recently in the USA, content moderation is a highly sensitive area with potential repercussions, of course, for democratic society and fundamental rights. In future, under the DSA, online platforms should issue transparency reports, which include information such as any orders they've received from member state authorities, the number of complaints received via their internal system, the number of suspensions and out-of-court settlements, and any automated use, any AI that they use for content moderation. So if your company hasn't done so already, it should think about initiating a transparency report regarding its content moderation practices. Then turning to the notice and action mechanism. As I mentioned at the beginning, the goal of the DSA is to ensure a safer online experience for citizens by reducing exposure to illegal content and dangerous goods. So key to this is a new notice and action mechanism. Under this provision, hosting services will be obliged to put in place mechanisms enabling either individuals or entities to notify multiple specific items of illegal content via one notice. And this is in response to requests from right holders in particular. He said it was much too burdensome to have to deal each time with individual notices for every single piece of illegal content. And priority has to be given to notices received from trusted flaggers. That could, for example, be a non-profit organization trying to combat child sexual abuse images online, for example. And in addition, there's an obligation to engage with certified out-of-court settlement bodies. So the rapporteur in this instance wants to include a new amendment to the DSA, which would call for a 24-hour deadline for platforms to remove illegal content that could have serious consumer health and safety consequences. Now, this amendment, which is being tabled now in a draft report from the rapporteur, who's the main draftsperson for the DSA report in the European Parliament, it still has to be voted, but it's interesting that that has been tabled now and is being seriously debated, because that 24-hour deadline will be quite a burden for platforms as well. And in an amendment that has been inspired by recent events in the US, the rapporteur has also proposed that a platform should only suspend accounts of public interest if they first receive the approval of a judicial authority. So that's another interesting new amendment. So an action point here would be for you to review your company's system for handling notices. And if you don't have a free, easy to use complaint system, you may want to start planning to introduce one. And also think about your relationship with trusted flaggers organizations in your area, because developing a kind of good, positive relationship with trusted flaggers will be important in this context.
And actually, Francine, let me jump in. What is a trusted flagger? Because that is a bit more of a European term than people in Silicon Valley may be used to.
Yes, a trusted flagger can't be an individual. It has to be a representative organization. So it could be a consumer group. It could be a non-profit. It could be a group that tries to tackle hate speech online, or tries to tackle material related to child sexual abuse or other detrimental material online. So it's quite broad, but the European Commission would help to kind of vet and decide on who can be a trusted flagger. So again, it's something that needs serious consideration, because of course, not all organizations are neutral and objective. Some organizations can have a particular agenda. So it's an area indeed that requires some careful consideration. So you should really think about who the trusted flaggers could be in your area.
Yeah, and we actually got a question, how does, do you need to certify a trusted flagger? In other words, is this something where each company has to determine who is trusted, or is there you think there's going to be some kind of objective standard?
Yeah. Yes, there will be a kind of certification process. How it's going to work in practice is still up for discussion, and the Commission is likely to bring out some guidelines afterwards. But you would hope that the industry players, the platforms themselves, will have some say in who is acceptable in terms of being a trusted flagger in their area. Okay, so then if we move on to the provisions on traceability, one other aspect of the DSA is the introduction of a kind of KYBC approach, as in know your business customer approach to online marketplaces. And under the DSA, online marketplaces would be obliged to adopt this approach to help identify who is behind the selling of illegal goods, and particularly to identify rogue traders, of course, on digital networks. And platforms would have to not only make sure that they have the information about these traders, they also have to verify the information to the extent that's possible and publish information on the traders using their platform. So in this context, it will be important that your company does make sure that it requests sufficient information from traders and has the means at least to partially verify that information. And then we get to a more controversial part of the DSA, and these are the provisions that are aimed at VLOPs. Now, VLOP is another ugly acronym in a town that already has lots of ugly acronyms. A VLOP is a very large online platform, and that's defined as a platform that reaches 45 million users a month, or represents roughly 10% of the European population. Now, VLOPs are subject to additional specific rules due to the particular risks they're seen as posing for the distribution of illegal content online, and for their potential to increase societal harms. So VLOPs will have to meet certain obligations, including risk management obligations, external risk auditing, and public accountability. And they also have to enable user access for information, as well as share data with authorities and with researchers. So there's a lot of sharing of data and allowing access to systems, which is very interesting, because then, of course, you can come up against issues such as trade secrets, competition issues, rivals being able to access information about your business, etc. So those are provisions to watch. And in this context, online platforms who qualify as a VLOP will have to appoint a compliance officer if they haven't already done so. They have to initiate annual independent audits at their own expense, and they have to consider new safeguards in the form of those codes of conduct and crisis protocols. So that's quite far-reaching.
Do you think it makes sense to have these different obligations for VLOPs? Sometimes you hear concerns raised that having these additional obligations will mean that illegal or otherwise worrisome content will sort of migrate to the shadows, or also potentially that these additional burdensome obligations will mean that growth and innovation in other smaller firms is going to be deterred, because firms won't want to grow to such a size where they're going to have to comply with these obligations.
Yeah, I think that's a very good question, because some larger companies are even beginning to complain that these provisions could be anti-competitive, because it's almost a deterrent to grow your business to a certain size, because otherwise you will develop all of these additional obligations. So there's an interesting debate going on about this in the European Parliament at the moment. And strangely enough, the rapporteur for the DSA report in the Parliament has tabled amendments saying that smaller companies also have to shouldn't necessarily be spared from some of the more far-reaching obligations in the DSA. So Crystal Schaldemose, she's a Danish member of the European Parliament who's in charge of the report for the moment. And she said that even small platforms need to follow many of the provisions in the DSA because consumers can also be harmed by, for example, illegal products sold on smaller platforms. So it's interesting that the focus is not only on the very large ones, but even increasingly on putting more responsibilities on the smaller players. So one of the other big differences, I think, between how the small players and the larger players are treated under the DSA is in terms of enforcement, because VLOPs will be overseen to a great extent by the European Commission. The Commission will have direct supervision powers over VLOPs, including the power to require immediate actions to address very serious harms. And platforms may offer remedies and commitments. So it sounds very similar to aspects of competition law, where, of course, the large players are also under increased scrutiny. So maybe moving on slightly, there are also extra measures for VLOPs regarding online advertising. Now, online advertising is one of the real targets of the Digital Services Act. A lot of members of the European Parliament are very concerned about online advertising that they see as intrusive and invading people's privacy. There are some even calling for an outright ban of profiling and targeted advertising completely, which I don't think will happen, but it's a very controversial debate going on at this moment. And under the DSA, intermediary service providers will have to make clear that the information displayed on their networks is an ad, on whose behalf the ad is displayed, and the reasons why, or the parameters used to decide why that ad is shown to that particular person. And of course, VLOPs will have additional requirements, including setting up a repository of all ads that have appeared in their system over the last year. So in this context, companies need to be ready to assess if you currently provide sufficient information about online advertising. Do you provide enough clarity from consumers regarding ads and who is behind them? And if you're a VLOP, you need to start thinking about setting up this repository, which will be also quite time-consuming and quite burdensome. So then finally, if I take a look at the structure and the wonderful, exciting issue of penalties. First of all, there's a multi-layered oversight structure foreseen in the DSA. Each member state has to appoint a digital services coordinator, which will be supported by a European Board for Digital Services. For VLOPs, the European Commission has the potential to impose fines of up to 6% of the global turnover of a service provider. So that could mean billions of euros for very large platforms potentially. And this enforcement mechanism is not limited only to fines. The Digital Service Coordinator and the Commission will have the power to require immediate actions, as I mentioned. They may ask for commitments as well. And in the most serious cases where a platform refuses to comply, it will be possible as a last resort for the Commission to ask a court for a temporary suspension of the service. So in short, it's not too early to start thinking about your compliance strategy, because the consequences of getting it wrong are very, very significant. Then maybe a quick look at the timetable. The European Parliament, like I said, is currently amending and discussing the DSA proposal. At this moment, there's a possibility to meet with MEPs. It's something I'm doing with some of my clients at this moment, to provide amendments to the draft proposals and to issue voting recommendations for the various committees, because we have, apart from the lead internal market committee, we have many other committees also feeding in opinions. The lead committee is expected to vote on the 8th of November, and the European Parliament is likely to adopt a final report in December of this year, if everything goes according to the current agenda. In the meantime, member states in the Council have begun their discussions to try and reach a partial general approach. And these two processes run in parallel to each other. And during this time, there's a possibility to meet with member state representatives, to reach out, for example, to the EU permanent representations of countries where your company has a particular footprint. That's something at this moment that I'm helping some clients with. And once the Parliament and the Council reach consensus, we then get into the trilogue phase, which are the three-way negotiations between the three institutions to reach a final consensus. And all throughout this process, you could think about getting involved in the debate, thought leadership in the form of opinion pieces, organizing workshops around your priority issues. So there's still a lot that can be done because the proposal will change over the next 2 years. Now, the minimum timeline for this to be adopted and take effect would be 18 months, which would be June 2022, plus 3 months for the regulation to take effect. But given that these are very complicated issues at stake, and some of the parts of the proposal are very sensitive, I wouldn't at all be surprised if the discussions don't run into 2023. They could even, at the latest, run into 2024, but then they run out of time because we will get into European Parliament elections and a new European Commission, and then it would be back to the drawing board. But I know the Commission is putting a lot of pressure on to move as quickly as possible. So that's a quick overview from me on some of the main points, and happy to take any questions, or if you prefer to group the questions together at the end.
Yeah, just before we turn to Claire for the DMA, there is a quick question, which is, these regulations really contemplate big companies dealing with other companies. And, a lot of US companies deal with individuals. So for example, a sales platform that has lots of individual users, is there some expectation that the platform would have to verify each individual or each individual item? How is that work? How would that work? Or is it just not clear at this point?
Well, according to the draft DSA, platforms would have to make an effort to know the identity of the traders. I mean, things like bank account statements, address, whether or not they're registered as a trader in official registries, etc. So platforms will be obliged to gather together a minimum amount of detail to allow the trader to be identified. Now, the platform doesn't have to go as far as trying to verify individual items sold by that trader, but it means that if a dangerous item, for example, is discovered, that you can trace back who actually put that item up for sale in the first place.
Okay, well, thank you. That certainly seems to add some cost and complexity, and especially for individuals who may sell, a $4 T-shirt or something like that. Very, very interesting. Well, let's turn to Claire to talk about the DMA, and also to give us a little bit of of maybe Google's perspective. Obviously, not speaking on behalf of Google.
Thank you, Ian. Yes, I should have said at the beginning that anything I say, I suppose, is my own view and not necessarily that of Google nor Cleary. So Francine has spoken to you about the DSA, and that's the first pillar of the EU's digital strategy. And the second pillar is the Digital Markets Act, or DMA. And the stated goal of the DMA is to ensure contestable and fair markets in the digital sector. Notably, this is not competition law, and it can't be competition law because it's been introduced by the Commission under a provision of the Treaty on the Functioning of the European Union, which is aimed at harmonising laws across member states. The Commission can't regulate for competition laws under that particular provision. And so while a lot of what I'm going to be talking about sounds and looks a lot like what we'd usually consider to be competition law, it's apparently not. So that said, the main difference and an important difference between what the DMA seeks to do and what competition law does is that the DMA is going to apply and be enforced in an ex-ante way. What that means is that the enforcement will occur before any harm occurs in markets. And that's a notable difference to how competition law usually works, in that competition law is imposed in an ex post manner, which is after a harm has occurred. And that nature of enforcement and competition law has given rise to a big debate in recent years, with people complaining that competition law and its enforcement is simply too slow to keep up with the pace at which digital markets move. And so the Digital Markets Act is aiming to address that criticism, amongst other things. So first, to just, I guess, look at the timeline before diving into what the DMA substantively says. The timeline for the DMA is very similar to the DSA, and the Commission published its proposal on the 15th of December. And I suppose if I take a step back, how this works is that the Commission publishes its proposed text for the DMA. It goes through Parliament and Council, where the text is debated and certain changes are suggested and potentially included. It then proceeds to trilogue negotiations, which, as Francine mentioned, involve all three of the EU institutions, that is the Commission, the Council and the Parliament. And once there's an agreement at that stage, the act can be passed into law. So currently we're in the red phase of the timeline. You can see on the screen there, it's being debated in Parliament at the moment. We had a big milestone at the beginning of this month because on the 1st of June, the EU rapporteur in Parliament, Andreas Schwab, who leads the Internal Market Committee, which has the main oversight of the DMA as it progresses through Parliament, published his report. I think he is a known critic of large American tech companies, and so a lot of suggested changes included in his report significantly increase the burdens, I suppose, that the DMA will place on companies who are subject to it if those amendments are ultimately accepted by Council and the Commission as well. As Francine said, in relation to the DSA, it's still possible for the DMA to, try to engage in discussions with members of Parliament and those in Council in order to air concerns or potential what to the DMA is to have a very close look at the text of the DMA and what it might mean for your firm, so that you can constructively engage in those discussions while that's still a possibility. So then, looking at what the DMA actually does, as I said, it lays down harmonized rules for ensuring contestable and fair markets in the European Union. And it only applies to undertakings in certain circumstances. So first, the undertakings have to provide core platform services as are defined in the DMA. And they also need to meet certain criteria, which include market impact, gateway status, and have an entrenched and durable market position. So looking at the first of those, what are the core services? Article 2 contains a closed list of 8 types of services which are considered core platform services. As you can see on the slide, those consist of online intermediation services, online search engines, social networking, video sharing platforms, number independent interpersonal communication, operating systems, cloud computing, and advertising. So while the list is originally closed, the European Commission can expand the list following a market investigation. So assuming you're a company that offers one or more of those services, the next thing for you to do would be to look at the criteria set out in Article 3 of the DMA, because you are assumed to be a gatekeeper if you meet the criteria set out in that article. So the first of those criteria are that your group turnover, so that's important. It's not related to the service in question, but the entire group is greater than $6.5 billion in the last 3 financial years. It might be worth noting here that Andreas Schwab in his report suggests increasing this to 10 billion euro. Seems that the intention behind that is to ensure that some European companies won't be caught by the DMA, although there may be other reasons for it as well. Alternatively, you can meet the criteria of having a significant impact on the internal market if you have a market capitalization of greater than 65 billion euro. Additionally, you must provide the service in question in more than 3 member states in the European Union. So if you meet that criterion, then the second thing to consider is whether the service in question functions as an important gateway for business users to reach end users. And then in this regard, the criterion you need to meet are that the core platform service has more than 45 million monthly active end users in the European Union, as well as having more than 10,000 yearly active business users in the European Union. And if that criterion is also met, the final thing to consider is whether you have an entrenched and durable position. And that's presumed to be the case if you've met the previous criteria for the last 3 financial years.
Claire, since I'm not a competition lawyer and you are, can I just ask, is EU competition law not enough? Are these proposals not too burdensome for companies that are deemed to be a gatekeeper?
Yeah, so I mean, it's, as I said, it's been subject of debate for the last number of years. I think the prevailing view is that competition law does not do enough. And I think in many respects, not everyone is opposed to new regulation and legislation, which will provide clarity as to what the law is and increase the times in which matters can be resolved so that investigations don't drag on for, up to 10 years or more, which we've seen in some of the high profile cases recently. However, I think some of the obligations contained in the DMA, which I'll discuss in due course, seem to be incredibly burdensome and don't provide for any opportunity to put forward any of the usual defenses, such as proportionality or objective benefits to end users, which you would usually see in competition law, but also other, I guess, any other legislation would usually provide for defenses. And so while I think regulation is welcome in many respects, the DMA does seem to, at least in its current form, try to achieve that while not necessarily recognizing the benefits that some of the practices it aims to target do bring to end users in certain circumstances.
Okay, interesting, thanks.
No problem. So yeah, so on that then, I guess it's a nice segue to move into discussing what the obligations are. So the DMA contains two sets of obligations. They're set out in Articles 5 and Article 6 of the DMA. And the regulations, or apologies, the obligations in Article 5 are commonly referred to as blacklist practices. So these apply off the bat without any possibility for them being further specified by the Commission. The obligations in Article 6 are sometimes referred to as grey list practices, and they also apply up front, but there is the possibility for the Commission to provide more details to certain platforms as to what they need to do in order to comply with it. You'll see on the slide there that the obligations come into force for gatekeepers within 6 months of them being designated a gatekeeper. Schwab in his report suggests shortening that time frame to 2 months. So that would not give very much time to companies subject to this to try to come into compliance if they weren't out ahead of that. Very quickly, I guess, and conscious of time, but also just to provide a brief overview of what exactly the obligations are. Article 5 in the Commission's text contains 7 obligations. The first, in Article 5A, aims to address the consolidation of data and use of data by gatekeepers across the various services in which they offer. So it is going to require a gatekeeper to obtain individual user consent for combining of data. And like a lot of the obligations contained in the DMA, there is some vagueness to it, and it's open to interpretation as to what exactly that means. For example, do you need to have an individual user consent moment every time a gatekeeper wishes to combine data, or is a one-off upfront consent sufficient for that? Article 5B then essentially prohibits the use of most favored nation clauses. Some of you might be familiar with cases that have been brought against Amazon, Booking.com in recent years. Essentially, the issue which this is seeking to address is that business users shouldn't be restricted in offering their services at different prices or with different conditions on other platforms. Article 5C then seems targeted at the service fee that various app stores charge for apps that have been distributed on their platform. And so what it seeks to do is to allow business users, app developers, to essentially offer users offers in alternative places, so that they can transact with their users outside the confines of the particular app store and not be subject to the charge that's imposed by app stores for various transactions that occur in app. Article 5D is relatively straightforward. It just seeks to ensure that users can raise issues with public authorities. Article 5E is essentially a prohibition on tying the use of identification services with core platform services. Article 5F is a prohibition against bundling of subscriptions and user registrations. Again, some ambiguity here. It's not clear, for example, whether it's still possible to maintain a single user profile for the user from which they control their consents and their settings across various services, or if that all needs to be broken out and each individual service needs to have its own account for the user. Then finally, Article 5G seeks to improve transparency in advertising services. And so it requires the provider of an advertising services to disclose various information, including prices, revenue shares, and whatnot. On this one, Schwab has proposed a number of amendments as well, which in one way are helpful in that they bring clarity to what exactly is needed in order to comply with the article, but on the other hand, make it very specific and make clear that the information that has to be disclosed is on a per advertiser, per publisher basis and per ad basis. So the information they have in mind is quite granular. Turning then to Article 6, the first two obligations here, Schwab suggests should become Article 5 obligations. It's not really clear what difference that will play in practice, but the first of these seems targeted at another thing which the European Commission is investigating in relation to Amazon, which is their alleged use of business users' data in order to compete with them. So, for example, I think what the Commission is investigating is the contention that Amazon uses its position as the provider of the platform through which sellers reach purchasers in order to find out all the information they want about the particular products being sold, which are popular, and so on and so forth, in order to build their own Amazon version of that product and then push that on their own store to the detriment of the original producer of the goods, to the benefit of Amazon. So that's what Article 6.1a seems to be targeted at. Article 6.1b.
Claire, a quick question, because, obviously in the United States, we have, we don't have a database directive. We have the First Amendment. Information can move more freely than in Europe. Would this kind of prohibition apply to what a company does anywhere, so that if a U.S. company looks at publicly available information from a U.S. company, it nonetheless could be subject to this European regulation if it impacts European consumers, or is there some understanding that this would apply to activities directed at European companies?
My understanding is that it would apply to activities directed at European companies. I think Europe's ability to impose its jurisdiction on the first scenario you described would be quite difficult, but I guess, as with a lot of what's in the DMA, I mean, it's difficult to see where that might go, but it would be more so activities directed at European companies. So obligation under Article 6.1 essentially is to ensure that side loading is allowed. So that's just to ensure that alternative app stores can be installed. So if any of you currently own an iPhone, the only app store through which you can purchase or download new apps is Apple's own app store. Article 6.1c, if it comes into effect, will change that. Article 6.1d is, at least from Google's perspective, one of the potentially most impactful provisions, in that it seeks to target in a very broad manner what has often been referred to as self-preferencing. So it requires that any ranking that occurs is done in an equal and fair and non-discriminatory way. Again, this is another provision where Schwab's suggested amendments contain a number of additions to the Commission's text. In particular, he makes clear that 6.1d should apply to not only ranking, but also the display of various results, and also suggests that where a core platform service features its own services or products, that equal opportunity must be given to third parties to do that in return for payment. And it's not clear which direction that payment should go, whether it's from the core platform service to the third party or vice versa. And that also any additional products or services shown need to be operated as separate commercial entities that are profitable on a standalone basis. And so if those suggested amendments to the Commission's proposals are accepted, and the ramifications could be quite large. For example, if any of you use Google search, which I hope you do, if you, for example, search for a restaurant near me, what you'll see often, and should see, is a map showing restaurants around you with the list of restaurants with the rating, contact details, so on and so forth. Or, for example, if you search for euro to dollar conversion rate, you'll probably see a box at the top of your search engine result page, which will show you what the current exchange rate is and give you some historical data as to what that was. On a very strict reading of Article 6.1d as proposed by Schwab, arguably any of those differentiated formats wouldn't be able to continue after the DMA. But again, there's ambiguity to it. It's not clear what a distinct service is, whether simply showing something in a different format counts, whether that's a feature, service, etc., etc. But on a harsh reading, it could have quite a significant effect. Article 6.1e then essentially just wants to ensure that customers are able to multi-home across apps and services. Article 6.1f seeks to ensure interoperability. Article 6.1g again is focused on improving transparency in advertising services. Then finally, we have 3 more provisions. 6.1h and 6.1i are both focused on ensuring data access, data portability for end users and for business users. And Article 6.1j, which is another which might have a potentially big impact on Google search, is a requirement to provide ranking, query, click and view data to essentially competing search engines. On one reading, it would mean that, for example, Google would have to provide data relating to all searches input by users, as well as what Google showed in response to that. And if that's the correct reading, it would essentially enable competitors to reverse engineer Google's algorithms and essentially not have to innovate and come up with that themselves. As I said, though, there's a lot still up in the air in terms of what these obligations will ultimately look like when it goes through Parliament and Council, but there is a lot there. It's also worth noting that Schwab has also suggested adding an anti-circumvention clause to the DMA, which would say that a gatekeeper is also prohibited from doing anything which has the same object or effect as the list of obligations contained in Articles 5 and 6, which could considerably increase the scope of the DMA.
Mm-hmm.
So, yeah.
Claire, could I ask something? When I look at this big long list, I was wondering, do you think the DMA is going to make it harder for US companies to do business in Europe? And is there a risk that the DMA is going to have a kind of chilling effect on investment?
It's certainly possible. I think one thing to bear in mind is that the number of companies that are going to be subject to this, at least initially, seems to be quite limited, in that it's the GAFAM companies, Google, Amazon, Facebook, Apple, Microsoft. And that said, in respect of those companies, I think it will certainly make it a lot more difficult to do business in Europe, at least in the way that they currently operate and would operate elsewhere. For example, I mean, an interesting example to think about is Turkey, where in relation to Google search, they took a case against the display of the shopping unit. Some of you may be familiar with the European Union's case against that, whereby the Commission found that the display of a different unit of shopping items at the top of the search engine was anti-competitive self-preferencing and required Google to make certain changes to it. The Turkish Competition Authority took a similar case, found the same, but was not satisfied with any alternatives to it. And so the only option that Google felt it had in order to comply with that was simply to revert to simply showing blue link results without any differentiated format. And studies which have been done on surveys of users, both business users and end users in Turkey since then, all show that both business users and end users feel that the reversion to simple blue links is unhelpful and has diminished the experience. It's hard to say what exactly the effect will be of the DMA, but I think, you know, examples like that might replicate themselves especially if certain defense options aren't open, which I'll speak to now. Because in addition to the categorical, I'll end any practice or harmful competitive effect, and nor on the basis that it can be objectively justified because it increases the end user experience or otherwise benefits innovation and so forth. I think it's interesting to note here that there have been a number of competition authorities of member states who introduced or are looking to introduce similar legislation to address perceived issues in digital markets. For example, Germany recently introduced its 10th Amendment to the Act on the Restraint of Competition, and it explicitly allows or at least places the burden on companies to justify certain practices. So it's possible to conduct is exempt if it's necessary or objectively justified on the basis of efficiency, innovation, or benefits to consumers. The EU Act at the moment doesn't contain any of that. In fact, the only defense options are either one showing you comply or showing that the viability of the service is at risk due to exceptional circumstances beyond the gatekeeper's control, or on grounds of public morality, public health, or public security, with a few caveats. There are also then some tweaks for non-entrenched gatekeepers. So as it currently stands, the DMA's obligations are fairly strict, and it is going to potentially have a significant impact on how certain firms operate. So then I guess looking to compliance quickly, there are procedural and substantive obligations to comply with. On the procedural front, the obligation is on the gatekeeper to notify the European Commission if the thresholds are met. It's possible when notifying the Commission to put forward arguments to the effect that, notwithstanding the fact the quantitative criteria in Article 3 are met, that you should not be considered a gatekeeper. If that's the case, the Commission must issue findings on that after 3 months and come to a final decision after 5 months. Even if the quantitative thresholds aren't met, the Commission can still open a market investigation to assess whether a certain company operates as a gatekeeper in a particular market. Substantively then, as I said, the obligations kick in after 6 months of designation, potentially 2 months if Schwab's amendment comes through. That's potentially very difficult for a number of companies. You know, there could be significant engineering changes required for certain products, and that is not something that can quickly be done often. Even in devoting significant resources to some of this stuff, it looks like it could take years of engineering work. Additionally, even if one wants to try to get out ahead, it's still unclear what exactly might need to be done. For example, it's not clear how you define a separate service. It's not clear how you define monthly or an end user. For example, in advertising services, you often have a publisher, well, you always have a publisher and an advertiser. Which of those, if either are the end user, or is the end user the person to whom the ad is displayed, which is, you often wouldn't consider sort of the person to whom an ad is displayed, an end user, particularly under the definition of the DMA, which is that someone is using the service not in a business capacity. And in addition to that, as mentioned, the final text is liable to look quite different to what it looks like now, and so it's hard to start building for compliance when you don't know what you need to try to build to meet. So anyway, all that said, it's important that one does try to achieve compliance, because the potential consequences for not doing so can be significant. Failure to comply with any of the obligations can result in a fine of up to 10% of global annual turnover, which for the companies likely to be subject to this can be quite large. If you're found to be systematically not in compliance, which is currently defined as 3 or more adverse decisions, Schwab again would reduce that to 2 or more adverse decisions. In addition to the fine, you can be subject to behavioral or structural remedies. And then on the procedural front, if you provide, false information to the commission or fail to notify them when you should, you can be subject to a fine of up to 1% of your turnover. So there's quite a lot potentially at stake. So that was that. I'm happy to take any questions.
Sure, and we're out of time, but we do have a couple of quick questions. So for anyone on the line who can indulge us, why don't we just quickly see if we can take those. You may want to pull up the chat, but there are a couple of questions. For example, would social networking that exists within a product be considered a platform subject to the DMA, or is it only really companies whose primary service is a social network that would be considered the platform?
Yeah, as I said, that's where the definition of service isn't necessarily clear, but on the basis that it probably falls within, it would fall within the definition of social networking in Article 2. So I would say it's likely to be considered a core platform service in and of itself, but to the extent it only functionally relies on another service, then arguably not. But yeah, it's hard to parse at the moment where lines between different services can or can't be drawn.
Right. Okay. I think that's very helpful. Okay, well, listen, thank you everyone for attending. We appreciate it. Please provide feedback and comments if you can. Sorry we couldn't get to all the questions, but as you can see, there's a great deal to cover. And, thank you very much, Francine and Claire, for excellent, clear, cogent presentations. This was a very, very interesting panel. And again, for anyone in the audience, if you'd like to get involved in the Center for the Digital Economy, please reach out to myself or to Roland Vogel. Thank you all and have a great afternoon or evening, depending what time zone you're in. Thanks. Bye-bye.
Thank you. Bye, everyone.
Thank you.